discussing, the state of freedom of expression in Kenya, anchoring from the Constitution. So in terms of background, I'll introduce the panelists in a while, but in terms of background, the IEA, through runs a program on the constitutional law and the economy. And the function of this program is to help our members, the Kenyan public, to understand the intersection between economic management and economic outcomes, the Constitution and the laws of Kenya. In the last 1 year, based on many things, BBI being one of them, one of the things that the IEA has committed itself more deliberately to is to create constitutional literacy. And by constitutional literacy, we mean just trying to make individual Kenyan citizens, the membership of the IEA, our partners, and obviously various associations, to form a habit of mind of understanding, or at least making reference to the Constitution and the content of the Constitution in public discourse, but more importantly, in their intersection and in their interaction with government. So that's basically the idea, constitutional literacy. And this is not just civic education, it's just basically to actually have Kenyans to have better grounding of what the constitutional content is and what its consequences, and what its implications are for any situation in public affairs, but also in the private domain. So part of what we do is we have undertaken to actually go through each chapter of the Constitution, and one of the things we do is to just provide a commentary, which would be useful, quite apart from the text itself, obviously, which many people hold nearly sacred, but just basically to actually ask somebody, if I was going to understand a narrative about what the content of each of the chapters is, what would it contain? And that brings us to our discussion today. What that means is that in trying to look at trends, looking at ways in which Kenyans communicate, one of the things that we found has not been sufficiently, not necessarily understood, but actually ventilated, and where I think citizens differ more than we think is necessary to government and institutions of government, is in the area of expression. And so when we talk about the freedom of expression, we prefer free speech, but basically the Constitution talks about it as freedom of expression. The first thing that you hear from one, in various mediums, whether you are on social media, whether in the national press, whether in discussions with leaders, the first thing that people hear is that freedom of expression has limits. So it seems as if, again, in our interpretation, before we talk about rights and ventilate about rights, the first thing that everybody tries to remind you is that there are certain limits. And our view is that perhaps that's not what is intended with constitutional interpretation, but also I think that limits citizens to actually second guess themselves every time we communicate. We communicate or express ourselves in various ways, so that the first thing that you're confronted with is that those constitutional rights are not absolute, as if anybody said they were, but more importantly, the determination of what people think is safe, should be said, is appropriate, comes from a whole variety of bureaucrats in government institutions, in which people's predilections about what we should interpret as the right to expression is. Now, secondly, as the Institute of Economic Affairs, we think that freedom of expression is important. One, both as a right in itself, under Article 33. And then the second part is that actually we can instrumentalize, and this is what is important to economists who study institutions, is that freedoms and rights, as others call them, are actually both important in and of themselves. And then the second is basically because you can instrumentalize them. And by instrumentalizing them means they can be a means to a goal, apart from being an end in itself. So for instance, the freedom of expression, and that right is why we are holding this webinar today, to have as many members, our partners, and obviously our panelists express their views around what we think is a very important subject. We know that in Kenya, I think we are beginning to see, or at least that's my very strong contention, is that we see very arbitrary constraints about what people can say, what they can communicate, who they can communicate with. And while we understand that those protections should come, I think one of the things that concerns us, again, I repeat this, is just basically that people draw lines on their own and decide that this is a no-go area and this is not, regardless of what the Constitution says. And in our view, that's not good for constitutional literacy, constitutional practice, and all that. The other point that we talk about shortly is that we think that there's a conflation about how rights are understood in Kenya. One of the ways in which it is conflating rights is people think that if something, or rather first, rights are actually given to citizens, meaning the state should take a backseat, but people speak about those rights are themselves owned by the state, and therefore their interpretations of how those rights should go. And by state, I mean either the judiciary, but also on the other side, the executive primarily. And what those rights mean necessarily should be what's comfortable for people in the executive, for instance, or in parliament and other places. The other thing that we see are basically trigger warnings and some language. This is not from government, but coming from very interest groups, very highly organized interest groups, about what they call trigger warnings and the demand by people that in conversations in the private domain, you should provide them with safe space where you shouldn't say things that they think you shouldn't say or beliefs that you think they shouldn't do. And so the language of tolerance, which in my view I did not see in the Constitution, at least not in Article 33, has almost become the view which determines what other people should say. And I understand the delicate nature of construction, I mean, of conversations and the freedom of speech. But I think we should discuss today one of the things that we do. I mean, one of the ways that we do. But the final thing that actually most concerned me about this is the press in Kenya, and as we're coming towards the elections, there's a tendency in this country to conflate words with action. And among the things we say are things such as words, you have to be careful about your words and how you communicate because it might lead somebody else to, quote unquote, do something that's wrong. And in my reading of the Constitution, I don't know how good or whether that is very, very informed discussion, but I think to hamstring thought and its expression and intellectual output, basically on what other people consider okay is what political correctness is. And I think there's a very huge arrest of political correctness in this country. I think, especially as you come towards elections, which allows us to let moments to pass when these things should be. So that's one of the reasons why we are here. And what we have today are three excellent panelists who will be speaking to us, presentations will be speaking to us. So we have Jacqueline Kagume, who's a program officer in our Law and the Constitution, Law and the Economy program. And what she'll be discussing is just basically the freedom of expression in Kenya, trying to lay out the foundation for what's the constitutional and legislative background to the freedom of expression in Kenya. And secondly, we'll have Daisy Amdani, who's the Executive Director of Crown Trust. And what she'll be talking about is some of the issues that we want to talk about here, which is basically to understand what's the demand, where is the demand coming from for limitations on freedom of expression by various interest groups. So this is not necessarily just the state itself, though the state, of course, can do that, but basically various interest groups. And thirdly, we're also privileged to have George Kegoro. He'll be speaking for the demand for limitation of freedom of expression, especially for political purposes, and some of what are the costs and benefits of that. So again, on behalf of the IEA, I thank you for being here. Just specific rules. One, as the speakers speak, we'll allow them to each speak for 20 minutes, and then we'll open up a session for question and answer. But if you have any questions, there's a chat box right at the top of the menu bar, which allows you to send questions. I'll try and process those questions. And then when the question and answer session starts, we'll send them to the panelists and they can answer that. So that's the first. The second, please keep your cameras and microphones turned off when our speakers are speaking, because we'll try to make sure that the cameras are focused on the speakers exclusively, so that with the recording, we'll be able to show this and obviously broadcast this. Please be aware as well that we are broadcasting these to our Facebook, our YouTube page, but also that we intend to edit this discussion and actually have it in a repository so that others can make reference for it in the future. So we'd like to let you know that it is being recorded so that at least you're conscious of that. Now, without further ado, I'll invite my colleague, Jacqueline Kagume, to make a presentation. Jacqueline, you have 20 minutes, sorry. And she'll be speaking about the freedom of expression in Kenya. What is the constitutional and legislative background? Thanks a lot.
All right. Thank you for the introduction, and good morning, everyone. I'm Jacqueline Kagume, and I'll be making this presentation today on behalf of the Constitution, Law and Economic Program, as Kwame has stated. So the presentation today will cover the legal background to freedom of expression in Kenya, or essentially the law relating to what is referred to as the freedom of speech in different jurisdictions. And I think Kwame has mentioned that. So here's my outline. I'll provide a brief introduction and define some of the basic concepts regarding the freedom of expression, and that is as it is understood globally, and some of the justification as to why the freedom matters. I'll then look at the law regulating the freedom of expression in Kenya. And here we have the Constitution as the overarching law, then the international law. I'll look at legislation, and while discussing the legislation, I'll also mention the institutions that have been mandated to implement various sections on, or rather that freedom. So the institutions whose mandates are connected to the regulation of freedom of expression. Then lastly, I'll highlight some case law and make some conclusions. So that's my outline. We go now to the introduction. And just as a way of definition, the freedom of expression is defined broadly as the right to seek, to receive, and to impart information and ideas. That's globally. If you look at most of the definitions of the freedom, almost everywhere, those are the main principles that are listed as underpinning the freedom of expression. Then different places go ahead to either expand the scope or just provide some additional specifications in terms of the scope of what the freedom covers. And so in terms of additional specifics, ours in Kenya, it includes the freedom of artistic creativity, academic freedom, and the freedom of scientific research. And I'll talk about the basic principle behind the right or behind the freedom of expression is that all persons, be they individuals, be they communities, should be able to articulate their opinion and their ideas without fear of either retaliation from the person or the authority against whom they speak, without fear of censorship, and without fear of legal action. I think we all understand the meaning of retaliation, censorship. That's the prohibition of certain speech, and then or legal action. So broadly, that's how freedom of speech should be understood. Then, in thinking about some of the rationale behind the freedom of expression, trying to understand, so why is it necessary, or why is it important? I came across some literature by a distinguished professor of law from the US called Professor Sheldon Nahmod, and he argues for three things, the first three things that I've listed there as being the main rationale for freedom of expression. The first is self-government, and I'll try and explain each of them very briefly. The first is self-government. The second is what he calls a marketplace of ideas. And the third is individual autonomy. I added the fourth, which basically is that it reinforces other rights. So under the first rationale proposed by this professor, he's a professor in Kent Chicago University and former associate professor of the Harvard Law School, and he's done a lot of writing, which I've referenced and you'll see at the end of this presentation. So for the first rationale, the professor argues that the freedom of expression is essential for effective self-government, and that it allows for meaningful participation in a country's democratic processes. So by allowing for free and restricted expression, individuals and citizens are able to make meaningful contribution to the country's democratic processes, some of which I'm sure my co-speakers will help expound a little on. And that's including being able to hold the government to account. Then the second rationale that he spoke about was what he called a marketplace of ideas as underpinning the rationale for this freedom. And here he's basically stating that the freedom of expression or the freedom of speech is important because in a marketplace of ideas, the better ideas eventually prevail and allow for competition. And I think this rationale is supported by some of the philosophy behind pluralism of ideas, which most of us might understand. So essentially, by promoting the freedom of expression, we are basically promoting or encouraging a multiplicity of ideas, which is in turn likely to generate the best ideas that would be crucial for development. So that's the reasoning behind the second rationale. And that rationale that the professor speaks about is that it promotes individual autonomy and self-fulfillment. So in terms of this one, I think we can understand it in the context of artistic expression, creativity, academic freedom. I think I've just, from the definition that I provided, that the freedom of expression extends to artistic expression, to creativity, to academic freedom. I think he's basically stating that by allowing full expression, then individual self-fulfillment allows for individuals to enjoy the rights in terms of their artistic expression, in terms of their creativity, and the other categories like academic freedom. So individuals are then able to achieve self-fulfillment. Then the fourth rationale, which I added, and which most of us, I think, would agree, and it's already also in different pieces of literature, is that the freedom of expression reinforces the enjoyment of other rights. And I think this is an obvious one, because when one is able to express themselves fully and unrestricted and without fear of the three things that I mentioned earlier, then they are able to demand for their other rights to be upheld, for their other rights to be respected. So, and subsequently, I'll also illustrate a bit of the connection between the freedom of expression and other rights. So that is the background or the rationale to the freedom of expression. So we go now to the law, and here I'll start with the Constitution, and the first we have Article 33 of the Constitution, which basically enshrines the freedom of expression. And as stated earlier, in the broader definition, even how it's covered in how the freedom is covered in our Constitution is almost the same way that I defined it in the broader global definition. And the freedom here is defined to include the freedom to seek, to receive, or to impart information or ideas, the freedom of artistic creativity, academic freedom, and freedom of scientific research. So that's the first part of Article 33. Then the second part of Article, the article then talks about the limitations, and it states that the right to freedom of expression does not extend to the things that are listed there. So it does not extend to propaganda for war. It does not extend to incitement to violence, to hate speech, or to advocacy of hatred. All these, I think, are subject to interpretation, although some statutes that I'll mention mention a little bit of some of this, but then some of it is also subject to interpretation. I will not discuss the limitations in detail. My objective is to primarily lay out what the law says. Some of the speakers, actually the two other speakers will dwell squarely on the limitations to the freedom of expression. So that's the Constitution. Then we go to the next slide, and here we look at the related rights. So I mentioned that there are other rights that are related to the freedom of expression, and that is Articles 32 going almost all the way to 38. In Article 32, we have the freedom of conscience, religion, belief, and opinion. Article 34 talks about the freedom of the media. Article 35 is on the right of access to information. 36 on the freedom of association. 37 on the right to assembly, demonstration, picketing, and petition. And Article 38 is on an individual's political rights. So, I mean, without trying to go into how each of these one relates, I think it's almost self-explanatory. For instance, if we talk about access to information, it's important. Being able to access information is crucial to helping an individual express their ideas. Freedom of conscience and opinion, I think there are obvious connections there that are not the main subject of the discussion here, but this is just to illustrate that these are the main articles that have direct relationship with the right to freedom of expression. The one that I'd like to maybe just point out a bit and speak to a bit more is the right in Article 31, which is on the right to privacy. And here, I think, in my view, okay, so if we read Article 31C, it provides that every person has the right to privacy, which includes the right not to have information relating to their family or private affairs unnecessarily required or revealed. And the privacy and subsection D then talks about the privacy of their communications should also not be infringed. So what I find curious is the last part, the part that talks about the right not to have their private affairs unnecessarily required or revealed. To me, it occurs to me that it is indeed a limitation to the right to freedom of expression in some regards, because then it means, or it could be interpreted to mean that one person's right to express themselves freely ends where another person's right to have their private information protected begins. That is to say that if the Constitution guarantees the freedom, an individual's freedom to right to privacy, and especially regarding family affairs and private matters, then it means that if you'd like to express, you cannot then freely express yourself on regarding another person's privacy, and I hope that is clear. But then again, I also know that that is subject to interpretation, different interpretation, and I'm sure different lawyers would interpret the term unnecessarily revealed differently. But it's just something to think about, because I think it serves as one of the limitations that are not directly listed. So that's the Constitution and freedom of expression. We go to international law, and under international law, we know that international law forms part of the Kenyan law under the Constitution by virtue of Article 2.5 and 2.6, I believe. Then under international law, the most prominent instrument that I will mention here, we obviously have the Universal Declaration of Human Rights that forms the basis of most of the other general rules and principles of international law. But specifically in terms of treaties and conventions, I'll mention the International Treaty on Civil and Political Rights. That is what we highlighted. And here under the ICCPR, the rights contained under Article 19 of the ICCPR are the main are the rights regarding to freedom of expression. The main tenets of this article is the right to hold opinions without interference, the right to seek and receive information, and the right to impart information. In specific terms, Article 19.1 reads that every person shall have the right to hold opinions without interference. And then 19.2 provides that every one shall have the right to freedom of expression, and this right shall include the freedom to seek, receive, and impart information and ideas of all kinds regarding regardless of frontiers, either orally, in writing, or in print, in the form of art, or through other media. The covenant also provides for some limitations and states that the exercise of these rights carries special duties and responsibilities and may be subject to certain restrictions provided by the law of an individual country. And this should be the limitations that are perceived are only those that are necessary for the respect of the rights or reputation of others, and for the protection of national security, or what they call public order or public health or morals. So that's how the freedom is stated under the ICCPR. Then we go to legislation. Here, there may definitely be more in other specific legislations, but the main ones that I highlighted, the four that are listed here. And I start with the Kenya Information and Communications Act. And this act establishes the Communications Authority and facilitates the development of information and communication. So it basically regulates the media industry and the broader communications industry. So we all know that the Communications Authority is the main regulator of the media. And another thing to point out from this is that the Act restates the freedom of the media and limitations to the freedom of expression. So we know that the freedom of the media is subject to the same limitations that are stated for the freedom of expression. So the Act just goes ahead to restate that. And then the other act that is relevant to freedom of expression is the Computer Misuse and Cybercrime Act of 2018. This act has been subject to a bit of litigation, as most of us are aware, and I'll talk about some of that a little after this. And this act basically provides for various offenses relating to computer systems to enable the timely detection, prohibition, prevention, investigation, and prosecution of computer and cyber crimes. So it establishes various offenses related to all these violations against freedom of expression in the digital space. So I'll talk about the litigation that was that surrounded that act just shortly. But the other one that we highlighted was the National Cohesion and Integration Act of 2008. And this one establishes the National Cohesion and Integration Commission. I think we all know the history around the formation of the NCAC. You can see the timing was 2008, shortly after the 2007-2008 elections. So the Act defines hate speech, amongst other things. So it establishes the NCAC, it defines hate speech, it defines ethnic discrimination, amongst other things. And hate speech, which is one of the things that is listed as an exception to the freedom of expression, is defined as where a person uses threatening, abusive, or insulting words or behavior, or publishes and distributes material to that effect. And the main intention behind this would be to stir ethnic hatred. So it's defined as such within the Act, and it's termed as an offense. So the NCAC has various, established by the Act, has various roles, but most of which seem to be sort of supervisory around the freedom of expression and sort of encouraging of ethnic cohesion and so on. Then we also have the Access to Information Act, which is an important one in terms of facilitating individuals and corporations access to information, which then helps to allow or facilitate the freedom of expression. So the Act was passed in 2016, and the main body there that has been mandated to facilitate or oversee that is the Commission on Administrative Justice, together with working with other institutions. So the implementing agencies, I think, these mentioned, they are the ones that have mandates that are connected to implementation and oversight of this act. So I've already talked about the Communications Authority. The DPP has been center, especially in implementation of the Computer and Cybercrimes Act, in following up on prosecutions around that. And he was one of the respondents in a petition that I'll mention shortly. Then CAC, the judiciary, obviously, for its role in administration of justice and dispute resolution. And I've also mentioned the Commission on Administrative Justice. So those are the main institutions. Then we go now to a bit of case law. And there is obviously a lot more, but we highlighted only two. And the first one is the case of Cyprian Andama versus the Director of Public Prosecution and another. And this case, we also had Article 19 was enjoined as one of the interested parties. It was petition number 214 of 2018. And so just a bit of the background of this case was that the petitioner challenged the constitutional validity of one of the sections within the Kenya Information and Communications Act that I've just mentioned previously. And he challenged Section 84D of that Act on the basis of that it creates an offense in criminalizing the publishing of obscene information in electronic form. So the contention was that this section of the Act creates an offense by stating in very vague and overbroad terms that publishing of obscene information is an offense. And the argument was that the Act, by creating this offense in the terms that it did, was a violation to the constitutional guaranteed freedom of expression. And the courts actually agreed with the petitioner. It was the High Court Constitutional and Human Rights Division. It agreed with the petitioner, and it made the declaration that first, that section 84D of that Act is actually unconstitutional and invalid. And second, that the continued enforcement of that Act, that section of the Act by the DPP against the petitioner was unconstitutional and a violation of the petitioner's right to the freedom of expression. So that was the first one, and it was delivered in, the ruling for this one was delivered in July of 2019. Then we had the second one, which is the case by the Bloggers Association of Kenya versus the Attorney General and three others. I believe Article 19 was also, again, amongst some of the interested parties that were part of this litigation. And here, the background was that the petitioners filed a petition that challenged the constitutionality of some of the sections of this Act. And their main contention was that first, there was inadequate public participation regarding the passing of the Act, and that the Act violated various sections of the Constitution, including Article 33 on the freedom of expression. So some of the sections that the petitioners were challenging were the sections in the Act that relate to false publication, publication of false information, cyber harassment, wrongful distribution of obscene or intimate images, and they were contending that in the way it is phrased, these sections are a violation to an individual's freedom of expression. Now, as a sort of a deviation from the ruling that we had in the previous case, where the court agreed, in this case, the court disagreed with the petitioners and held that the need to protect the wider public from the dangers that are in the cyberspace outweigh the allowing or the granting of that petition. So they found that the provisions of the Act actually protect public interest, and in the court's view, they said that the Act protects public interest. So the court dismissed the petition and held that the Act was valid and not in violation of the fundamental rights and freedoms. So all the sections that had been previously impugned were upheld. So this ruling was delivered in February of 2020, so less than a year after the previous one that I had talked about. So those are two different court cases with different rulings on regarding the freedom of expression. I'm not aware if there's an appeal regarding the second one, but as it stands, I believe it's still so. The Computer Misuse and Cybercrimes Act is still in force, including all the sections, given that the court disallowed that petition. Excuse me. Then just now as I conclude, those are basically, what I provided is basically the main law, the main legal background in terms of the Kenyan law on the freedom of expression. As I mentioned, the other speakers will expound on the limitations. In conclusion, I'd just like to restate why we believe or we think that freedom of expression is, regardless of the limitations, is important. I did mention earlier in about some of the rationale that is provided, but just to restate that it is central, or it is important because it's a foundation for other rights. It allows for an individual to be able to seek for the respect or have or demand rather for the other rights to be respected. Then secondly, I'll just reemphasize that it's important for stronger democracies, and I believe George will be speaking about this, basically by promoting electoral accountability, by promoting the ability to question authority, promoting it. Essentially, it promotes the development of a stronger democracy. Then third, we have the other reason why it's important is that it promotes transparency and accountability. And then again, obviously, this is linked to number two, because even when it comes to things such as public finance management, things such as public service delivery, the only reason why we are able to call consistently for accountability and to hold leaders to account is because there is freedom of expression is guaranteed. Otherwise, in any kind of demand for accountability would be met by some sort of retaliation or action by those in authority. Then lastly, it is our view that by encouraging and promoting the freedom of expression, all segments or all sections of the society are able to have adequate representation. And I believe Daisy will be speaking about this. So in terms of having the voices of the marginalized and minority communities heard and included in whatever development agenda is specific or important to them. So in summary, that is the legal background and some of the conclusions that we make. Thank you. Back to you, Kwame.
Right. Thanks, Jackie. I'll just say three things. One, I think what you've talked to us about tells us about the interconnectedness of rights, bringing me to the two reasons that I cited, that constitutional protections are an end in themselves, but often people see them as instruments for other things. So as you say that, for instance, the freedom of expression allows questions of conscience to be brought down. It allows for accountability, actors to work, keeping government in shape, enabling democracies to thrive. It also drives economic progress. And then you concluded by taking us through case law, showing two different trends, I think, that we hope to reconcile, that in some instances, courts in Kenya confirm the constitutional protection in Article 33. In other cases, they say that there's a legitimate public interest in some kind of interpretation. So we'd like to see whether there are patterns there or not. But I think that's where we are. So we have Kenya does not lack a legal standing besides the constitution itself for other for freedom of expression and expression, the policy around freedom of expression. So now we'll go to our second speaker today. Second speaker is Daisy Amdani. She's the executive director of the Crown Trust, and she'll be speaking about getting us from the law and the case law now to practice, and she'll be getting us to understand whether there are demands, what demands she sees on the freedom of expression by interest groups. How do interest groups of different kind, and she represents one, what are the demands for limitations of freedom of expression based on the law, but also just what might be other interests on limitation of freedom of expression. I don't know that there are people who actually think that the freedom of expression as expressed in the Constitution should be expanded. One of those. We shouldn't qualify the freedom of expression, but we'll get an opportunity to discuss that. So Daisy, welcome, and thanks again for being a good partner to the IEA. Daisy, please switch on your microphone and your camera, and yes.
Can you see me? Can you hear me? Hello?
Yes, we can hear you and we can see you. Yes.
Good morning, and thank you so much for this opportunity. I want to, first of all, start by saying that, Kwame, I do not represent an interest group. Women are not a special interest group. I don't know how many times I can say this. I know they are classified that way. I know even right now in Parliament, the Senate is pushing a bill that is seeking to provide for the 2/3 gender principle under special interest groups. But I say that I must insist that women are not a special interest groups. They are part of the citizenry, because if we comprise over half of the population and we are an interest group or a special interest group, then it means that men are also an interest group because they're the other half. So women are not a special interest group, but be that as it may, for the purposes of this conversation, we will talk about really just freedom of expression by different groups of interest who have similar interests. Whether those are special interest groups is a totally different thing. And I'm hoping that I will not veer off in terms of the topic, but what we do know is that, and from Jackie's presentation, is that the freedom of expression is a very powerful tool. And I think that one of the things that the Constitution 2010 has done for us is that it has unlocked the potential for us to be able to use this tool as a way of being able to inform and to sway opinion towards a particular persuasion. And so interest groups, and when we talk about the different groups that are there, for instance, like women, trying to express ourselves around the reasons why we should be able to enjoy some of those rights that are accorded us in the Constitution. But I'm going to speak generally, not specifically only to women, but also to just the wider different groups that are now expressing themselves and getting themselves heard, because we have unlocked this potential and they have understood that actually they have a right towards this. So it's important to understand that the interest groups respond to certain things, but also seek to sway public opinion. And interest groups are diverse, not just the way we think about them. We may think about women, we may think about youth, persons with disability, whenever we're talking about these special interest groups, like you know, the emerging groups that are today also seeking recognition. But we also see that political parties are also interest groups, and all of these are looking for ways of using expression of interest for more or less to guide and or control public attitudes, okay? And it's important to understand that this is such a powerful tool because you can either, if you favor a certain specific policy, or you're willing to convince decision makers of certain merits or demerits of a certain legislation outcome proposal, we are seeking to, you can move towards impacting the outcomes of those decisions, which is why I think that there is demand, not so much by interest groups, but mainly duty bearers, to seek to limit this expression, because it's almost like taking power away from them. For the longest time, we've seen the people who have been controlling expressions of interests, and controlling it in the sense of how far your expressions can go, whether it is through the media. We know that media is such a powerful tool of being able to convey a message or to express your message. But the control of the media in the hands of duty bearers, or in the hands of people who hold a certain persuasion, can actually mute and make it look like nobody is expressing themselves. Social media, we've seen how that has been used. And in fact, it has become a very, very powerful tool for expressing oneself and for groups to be able to express themselves. However, we have seen that that space now is being distorted, very seriously distorted, by duty bearers to either divert attention from certain things, or even become purveyors of information that is not necessarily wholesome. Now, we have also seen, and I'm now going to focus on issues of the limitations on those freedoms of expression, because there are so many ways that these expressions are trying to be limited. And we've seen one of the emerging things, and I think it's a very negative thing, something that is being called now what we know as the cancel culture. We've seen it a lot in the more established democracies out there, where tools that have become very popular for expressions of interest by different groups have become so powerful towards influencing direction in a certain place. But we've also seen that the people who control these tools are also able to shut you down in an instant. We've seen people, you know, your social media accounts being cancelled. And we're also seeing it here. I mean, everybody was quite a few people celebrated when it happened to Donald Trump. But now more and more people are beginning to see that that cancel culture is coming closer and closer to home. And we find that that limitation on the freedom of expression is being curtailed in a way, and by people who hold instruments of power that who are in control of instruments that we ourselves have been so used to almost like taken advantage of, and we've been almost certain that they'll always be there available for us. And I'll give you a case in point here in Kenya right now. We all know of this buyer beware which is controlled by one of our colleagues, where they call out duty bearers, they call out certain people, they get information and they put it out there. And it's quite a large group. They have currently, right now, been blocked, and they've reached out to us and asked us, is there a way that you can assist us? Because our account has been blocked and has been reported by the government to Facebook that they are likely, that this group should be blocked because they are likely to incite they have the capacity to incite people to violence, pre-election violence. And so you see, for us, like, this is a timely conversation, because even when we talk about certain limitation of rights, we know, like, for instance, for the women, the refusal by government to implement the 2/3 gender rule is a sticking point, where we have been seeking to mobilize and come together towards being able to do some advocacy activities to push for the implementation of this law. But now we have, and I was happy to see yesterday that the courts found the COVID restrictions, the limitations that government has put on people coming together, the Public Order Act, and all, have found it to be unconstitutional, because they've been using that to curtail people's rights, so that one group is able to go out there and express themselves very freely. But if you don't hold a similar persuasion, they will find a reason to limit your participation. So we're beginning to see these limitations coming in. They are being prescribed by law, but they're being prescribed by law, and yet they are in violation of the law. They claim that they are serving certain purposes or a legitimate aim within, the protection of the people, health protections and all. Yet we see it is varied. It is, for one group, it is different for the other. So one set of rules for the other. We don't see the purpose that it is intended to achieve, so that while they say they are protecting people from COVID, you wonder if those who hold a persuasion that the government is favored to, a favorable persuasion with government, if those are not people who spread COVID. So these limitations are discriminatory and in violation of the law. And even internationally, and I think Jackie touched on some of them, there is international consensus that any restriction can be done. It is necessary, but must be proportionate. And it must be proportionate to the least restrictive means to achieve that aim. And so even as we go towards the elections and we are seeing coalitions, formations, and everything, this is something that we need to take in mind, because it's not just about interest groups in terms of women or persons with disability or certain groups, but also you may be women who are considered to hold a certain persuasion. Therefore, your expression may be curtailed under the guise of certain protections and necessary restrictions. How do we go about that, particularly when we're dealing with a government like ours that doesn't obey court orders? So what does that mean? Because international consensus says that indeed you can prescribe limitations, but also government should not also determine what ideas or information should be placed in the marketplace, but they seek to use these restrictions to determine what gets into the marketplace of ideas. And so this is something I think we need to look at more closely. I mean, I really don't have a clear answer for it in terms of how we go about it, because my biggest concern is a regime that has shown itself from the beginning to be against the rule of law. They openly violate the rule of law. I don't see them suddenly becoming born again and suddenly obeying the law. So I think that these are conversations that are important. When we look at the accusations that are coming from government, where they accuse certain interest groups of legitimate, of having certain threats, like now what has happened to the buyer beware group, where they are accused of having the potential to mobilize pre-election violence. How then does one, how do we counter this? Because it is the state that is now going to an entity like Facebook and saying you need to shut these guys down because they can incite people to pre-election violence. Yet it is one of the groups that has really called out a lot of malfeasance in government and among leaders. And so it has the potential to demand for accountability or to expose lack of accountability within government. But now they are being cited as being a threat to national security and the interests of the country. So how do we counter that as civil society groups or those groups that are accused of this? Because there's that presumption that national security restrictions, of course, are necessary. We cannot say that national security is unnecessary because we've all been there. We have the memory of the recent events in 2007, 2008, and we know that national security and internal cohesion is very important for the survival of our country, for the survival of our state, and of course, public order. However, how do we, within the context of securing the survival of our state and security, protect the expression of interests, especially at a time like this when we know that our country is on tenterhooks, in the sense that we have a multiplicity of issues that are affecting Kenyans, the economy, the health crisis, the political crisis that is unfolding in terms of leadership that doesn't look like what they want to transition peacefully. And so how are we able to call these out in the midst of also demanding for our rights as the different groups, women, the right to inclusion and the implementation of the 2/3 gender principle, the young people who are often the people at the wrong end of the stick when it comes to issues around security, and we've seen it with extrajudicial killing. So where does the balance between the protection of the state and the cohesion of the state versus limiting, where do we strike this balance to be able to ensure that our expression is not curtailed under the guise of seeking to protect the state? Whereas when we know that in most cases, a lot of the threats to security are actually driven by the political actors and not necessarily civil society actors. And I'm not saying that civil society actors cannot, but how do we strike this balance between protection and limiting these rights to ensure that there's the free flow of information, free flow of ideas, free flow of demands, while also ensuring that the safety and security of the nation is guaranteed. I think that we know that, and I'm not saying that rights cannot be limited. They can, definitely, and I do believe that there is a legitimate reason. There are legitimate areas where we can say for sure the rights can be limited. They're already spelled out anyway in the Constitution, in propaganda for war, incitement to violence, hate speech. Although hate speech has been meant to mean many things, advocacy for hatred, it's there in the law. However, there are certain forms of speech that because they rub people up the wrong way or point out certain things that do not necessarily favor the political actors, that are then considered hate speech, things like pointing out corruption, pointing out the failure of the government to implement certain rights and privileges and entitlements for the enjoyment of other rights. These can be, the state tends to term them hate speech, matters of human rights. We've seen the demands, the demands for the stopping of extrajudicial killings. Many of these have been termed as incitement to violence, incitement against government. So how do we guard this? And in the interest of public interest, while also ensuring that we are whatever the state is protected, we are protected, and the role of the freedom of expression in governance necessary for transparency, accountability in a free and a democratic state is guaranteed. So I think that there are many questions, and I don't know if I was supposed to give answers. I don't have the answers. I have many questions myself. I am concerned that I am very concerned that with the level of intolerance that we are beginning to see and the level of desperation that we're beginning to see among the political elite, that anything that goes against the grain would be limited under the guise of threats to certain freedoms and certain entitlements. And so I think that in going forward as civil society actors, we must look at the laws that are being put out there, because we've seen several efforts by this administration seeking to limit certain expressions through law. I think even through some of the things like the recent taxation on social media and all. I think that that is also, while they may be going after it because of revenue, they're starved of revenue. I do think that to a certain extent, it does create certain limitations. The more expensive it becomes for people to be able to access mediums that are free for us to use. And of course, we know that social media has really given a lot of freedom of expression. You know that the president himself also took off from social media because he was constantly being taken to task. I know that it's also a space that has been abused in some cases, but it is a good space. We know Kenyans on Twitter have been able to demand certain things. So when we see excessive taxation coming up against, being brought onto these platforms, I think it is partly some kind of, it is an attempt to limit the expression. So I think that whatever limitations on expressions of interest, freedom of expression, should be prescribed by law, and we should be able to scrutinize these laws, because we know that under this administration, we've seen many laws that have been crafted that are against the Constitution. It should be formulated in such a way as to enable citizens to be able to regulate their conduct. If that can't be done, then those kind of limitations, we should not entertain them, and we should be willing to rise up against them. We should look at how national security, public order, public health issues are framed. But then on the other hand and for me this is a particular concern, is the increasing cancel culture that we are seeing coming up on people, against people who hold a different opinion, particularly with regards to what are considered moral issues. So that if you are not pro a certain persuasion like LGBTQ or these kind of things, you are actually canceled. And the cancel does not even extend only to things like social media. You're canceled even in terms of being able to access certain things. So it's almost like you're not allowed to hold a different opinion. And I think this is a very worrying trend that is becoming, more pervasive. That if for instance, I'm a Christian, I'm born again, I'm looked at with great suspicion because these are those people or who may not have this persuasion. And so there are certain limitations. And I think that these are things that we need to talk about, because with the cancel culture, which is coming increasingly our way, where if you're not removed from off a platform or your things removed off platforms, then there is bullying, cyberbullying that comes to sort of like shut you down. And of course, as we go towards elections, particularly for women, this is also something I think that we should be concerned about, because the propensity for us to have this bullying, defamation, spreading of false information, that is also a kind of limitation on people's expression. So women who want to campaign, I know this happened. I mean, I can give a real example of a lady this happened to in 2017, who she was seeking to vie, and they did a kind of a Photoshop on her and showed her in a very compromising way, nudes, and with her head placed on, and then they were circulated around WhatsApp groups and other social media, and it had a very devastating effect on her personally, her home, her marriage, and then you have to chase after that. So there are so many limitations that are brought about. Some are legitimate, but others are sinister. And I don't know if we have enough control to be able to curtail this. We also, what happened with the Cambridge Analytica, that also, by the way, is a kind of, when you distort information that is out there, can that also be considered a limitation of people's expression, or making people think things differently? I do not know. But at the end of the day, I think that for us in a democratic society, we must ensure that whatever limitations are proposed must be proportionate to the aim, so that if you are seeking to ensure security, it is not, you do not ensure security by shutting down what dissenting thought or dissenting expression. Even religiously, I mean, the fight between Christians and Muslims, that you cannot propagate your beliefs or your religion, is the restriction that is put in place. Is it the least restrictive in able to fulfill that aim, so that while people are able to go about their things, they're able to express themselves, but within certain restrictions, like what the Constitution provides for, that you're not inciting people to war, you're not inciting people to hatred, then the overriding public interest, politicians have a tendency to think of themselves as the only public. And so for them, anything that is, affecting their own interests, they make it the public interest. So I think that we should look at some of those limitations in terms, or in light of some of which public interest is it that is being protected. But overall, whatever limitations may be put in place should not jeopardize the legitimate expressions of interest of the different groups to be able to make themselves heard, to be heard, and to be able to further their interests, if indeed they are overall in public interest and not affecting public good. I think I'll stop there, Kwame. Thank you.
All right. Thanks a lot, Daisy. So basically, Daisy, I'll cite two things. So first, Daisy, when I say interest group, I didn't mean interest group in the pejorative sense. I meant interest group in the sense that you have a constituency of people whose views and interests you'd like to present for the public to understand. Now, I think Daisy has mentioned two things before we go to the next speaker. One of the things that I think about is that Daisy has mentioned the question of a fantastic example and insight, which is basically that there's an extent to which taxation on social media or forms of communication is applied as a regulatory instrument to limit speech. Or rather expression. Now, whether that's been tested in the courts or not is a different matter. But we need to understand that the instruments for regulation are not just regular censorship and banning things. And once in a while, of course, as you know, state agents in the older days used to walk into newspaper rooms and actually take newspapers or try to use this state power. More recently, what the state tries to do is use state power or state corporations that will not advertise with specific media houses by virtue of the fact that they have covered one thing or they are considered to have one interpretation of political events or commercial events or the other. So those are available. And I think taxation as a mechanism for managing free speech or limiting free expression is an idea that we should track more closely. And I'm grateful for that, Daisy. The second point is you've mentioned the question of cancel culture. And I am myself a bit conflicted about cancel culture because I think what you mentioned is true and the bullying and everything else. But I tend to try to distinguish between a private institution, well, be it Facebook, be it Twitter, or all the other social media houses, which are private entities to begin with. And they're entitled to tell me that, Kwame, we will not allow you to say this or that. If those instructions do not come from a government or state operatives, then I agree that somebody who has their own private property could tell me what I could not say or say in their hearing or in their house. That is acceptable to me. What I find interesting with the cancel culture, though, is I need to mention this instance, is that I was very surprised that there are these bad bearded men called the Taliban. And they have at least 3 Twitter accounts. And another guy called Donald Trump, who was the president of the US, was taken out of Twitter. And in my view, the application of the rules that allows for Donald Trump to be kept out and for the Taliban to be kept in is something I'm still debating myself. In as much as the instrument that allows this is a private instrument, Twitter, which I use as well. I find it pretty useful most of the time. But I would like to understand what their reasoning is that I counted myself. I counted specifically, so this is my voice. Twitter has 3 accounts by people who are known, communication specialists, but even some of the leadership of the Taliban. And then Donald Trump's expressions were found just because he was deluded about whether he lost the elections or not. He was thrown out of it. That looks disproportionate for me. And as citizens, perhaps we can have a discussion about what that means, about private censorship and all that. But I think because the instrument is owned by by Twitter, they're entitled to tell me that I cannot express or not. And it's upon me then to interpret whether they're a good partner for that purpose or not. But the state does tend to have an obligation to be more neutral and actually to facilitate. And that's part of the reason why, even with the question about, what is it called? This group that Daisy mentioned that was working, Analytica, that was working for one political party in Kenya. If they were not paid with state money, then I actually think Kenyans exaggerate the effect to which they had on the elections. I think the point that people had and the tension was already there regardless. The deception is a different matter altogether that can be solved through private law and all that. But expression, in my view, I'd rather have much more expression than do two. And the final point is that when campaigns come about, sometimes we use the reference of fear and social fracture, which already exists, as pretexts to curtail expression and all that. What Daisy mentioned, which I think she should have pressed a little bit more on how free speech is sometimes used, especially in political rhetoric and language, in ways that harm personal, or rather is intended to actually harm women or their prospects for political office, because the assumption is they're supposed to be more proper and all that, and that they're not supposed to be. But I think in that avenue. If somebody does that, obviously we have laws against libel and slander, which should be dealt with, which should be used to deal with that. Now, I bring us back now to our third speaker, and we are discussing here the demand for limitation of free expression, freedom of expression for political purposes, for very, very obvious political purposes. And we are privileged to have, like we were with Daisy and Jackie, George Kegoru is the Executive Director of Open Society Institute for East Africa. So George, welcome.
Thank you very much, Kwame, and thank you very much, the preceding speakers, for very interesting discussions that make it easier for me to say the things that I'd like to share with the audience. So Kwame asked me to speak about the pressure to limit political expression, and political expression is going to be particularly important during this season when we are going into elections, when the chief means of campaigning obviously is political expression, and the questions that arise traditionally is how much of it should be allowed, what limitations, if any, are necessary or reasonable, and why and for what reasons are those limitations reasonable. And Jacqueline has touched on some of that, as well as Daisy. So I came across, I'll make some eclectic quotes that I came across that then will lay the context for some of the problems that and dilemmas around expression that I'm going to discuss. The first one is this report. It is a colonial report. It's a 1960 annual report for Nakuru, and I'm quoting now. An African's first loyalty is to his family and tribe rather than a political party or other non-tribal organization. As general elections approached, political loyalty became more and more synonymous with tribal loyalty. The main lineups were Kikuyu and Luo for KANU and the Kalenjin Abaluya for KADU. This is sort of a readout by the colonial government of the political situation in Nakuru as at 1960. The following year, the same report, which was an annual report, makes the following assertions, and I'm quoting again. Intertribal tensions increased markedly as the year wore on. The Kalenjin make no secret of the fact that they are stockpiling native arms against the inevitable day, probably after independence, when they will have to fight the Kikuyu and perhaps the Luo for control of their own areas, including the upper and middle rift. The tribal antipathies are now so great on some farms that the Kalenjin members of the Agricultural Workers Union would refuse to take part in a union strike alongside Kikuyu members and would automatically take the opposite line in any controversy. This is the 1961 report on the state of political affairs in Nakuru, as produced by the government, the outgoing colonial government as at that time. So I'm citing these reports to make the point that the discussions that we are having about political expression and the tensions and problems that arise from dealing with it is not a new problem. It is a very, very old problem and goes back to the pre-colonial period of this country. So there is no, in case we are tempted to think that these problems are just recent as or came to us in 2007, for example, that is not true. It's a problem that we've had as a country for a long, long time. So that in 1964, there was, after there were ethnic tensions along the Rift Valley and the Nyanza border areas, a meeting was convened in the leadership of the what was it called? The regional president. They were called regional presidents for Rift Valley, one Daniel Arap Moy, who was a regional president for Rift Valley, and one Johnson Keragori, who was a regional president for Nyanza, to discuss clashes along the common border between Rift Valley and Nyanza. And the clashes were between the Kisii people and the Kipsigis people. At that meeting, one of the remarks that come from a review of what transpired in that meeting is that the making of inciting speeches was not condemned. The leaders at that meeting preached only peace. And subsequently, on the 5th of April 1967, the question of unsavory and inciting utterances was raised in Parliament in the course of the debate. The Assistant Minister in the Office of the Vice President at Home Affairs, Mr. Matano, remarked as follows. Mr. Speaker, I'm quoting Matano, on this question of the clashes between the Maasai and the Kipsigis, so there were clashes between the Kisii and the Kipsigis, and there were also clashes between the Maasai and the Kipsigis. So Matano is speaking, I quote, as on this question of the clashes between the Maasai and the Kipsigis, there have been some incidents and we do not want to deny it. There have been a few incidents here and there, and I regret to say that with regard to a lot of those instigations and some of the things that have been happening on the boundaries, the blame really lies on some leaders of this country. I would not like to say which leaders because I feel it is irrelevant, but I feel that if we restrain ourselves and try to help our people to try to understand one another more and more, I'm sure, Mr. Speaker, we shall have less and less of these incidents. That's the end of the quote. So again, I'm citing this to say that the problems of speech and political speech and its contribution to insecurity, in particular ethnically instigated insecurity in the form that we now understand it, is an old problem in the country and isn't necessarily only a recent problem as we may have as we may think. So the next major occasion when these discussions came about was during the commission of inquiry into tribal clashes, the one commonly known as the Akiumi Commission. The Akiumi Commission was set up by President Moi in response to and to investigate the violence that occurred in parts of the Rift Valley and the coast starting 1991. It is known that, and this is discussed in the report of the Akiumi Commission, that there were 3 political rallies that happened in September of 1991. One rally took place in Kapsabet, the other one took place in Kapkatet, and the third one took place in Narok. There were just 3 rallies. Those were rallies by the KANU leadership, and KANU was reacting to demands that are taken a foothold in the country for multi-party politics. And in those rallies, the KANU demand emerged that if there was sustained demand for multi-party politics, then multi-party politics should be accompanied by Majimbo. The country should then adopt the Majimbo system that had been in place in the first years of independence, and then that had then since been abolished. There was a specific understanding of Majimbo as used and preached by KANU during those rallies. That understanding was a form of ethnic federalism and a form of ethnic balkanization, in terms of which ethnic groups living in the country, and particularly those living in the Rift Valley, would be required to live and relocate to other parts of the country. So the condition was, if you want multi-party politics, then those of you who are viewed as wanting multi-party politics must are contrary to the wishes of the communities that consider themselves native to the Rift Valley. You must leave the Rift Valley. That was in September 1991. On the 29th of October, just a month after the rallies, the violence started in parts of the Rift Valley, first of all at Miteite in Nandi, and then spread to other parts of the Rift Valley, including Olengurone, into early 1992. And by 1993, the violence had spread significantly throughout the Rift Valley, all the way to the northern parts of the Rift Valley, to places such as Laikipia, and so on and so forth. So the commission was the commission of inquiry, the Akiumi Commission that came tried to understand how that violence occurred, and the report of that report is clear that the violence was sudden, was organized, and its onset was sudden, and it also ended as suddenly as it had been organized. Now, the report makes the following conclusion, and I'm quoting again: the Majimbo rallies appeared to be intended to pass a message to the Kalenjin community that the path their leaders had chosen was to stick in Kanu, and any other political thinking had to be resisted by use of arms. We do not think that the clashes that started at Bitete in Nandi was a coincidence. We think, like in other parts of the country, they were carefully planned to exploit the existing Nandi ambition to recover ancestral land and drive away Madoadoa. So this is the Akiumi Commission grappling with how do you explain a sudden onset of political violence, and it linked the political rallies, the three political rallies in part of the Rift Valley, with the violence that happened. And this is relevant to the discussion we are having, because that discussion tends to ask the question: what are the linkages between, what can a dangerous political speech lead to? And obviously, dangerous political speech can lead to violence. And according to the commission here, this is an incident in which the speeches in the Rift Valley were the causes of the violence that followed in large parts of the Rift Valley through 1991 and 1993. There's a long discussion also to the effect of how the government responded to the violence, and the responses to the violence, according to the commission, were partisan, were incompetent, were meant to cover up, and were half-hearted, and so on and so forth. I would like then to, I'm just sort of spotlighting incidences in our recent history that then try to discuss those linkages. I would like to then discuss the next major discussion, the next major flashpoint where speech or expression and political violence was discussed, was in relation to the 2007 violence that followed the elections that took place in that year. Again, we have here the privilege of the Waki Commission that investigated that violence and tried to explain or to build an understanding of how the violence had come about. Throughout the body of the report, there is reference to speech and expression as forming part of the build-up to the violence that exploded at the end of 2007 and went on into the beginning of 2008. So there was violent speech during political rallies. in different parts of the country. But there was also speech or violent speech through vernacular radio and other forms of non-vernacular radio, including radio, the FM radio stations that are not necessarily vernacular in nature, but there's a finding and a discussion of incidences of speech and expression through radio and through media as forming part of the long build-up to that violence. There's a long discussion about the role in particular of CAS FM as a radio station. And you will all recall that CAS FM and its activities ended up forming part of the interest of the International Criminal Court because one of the presenters at CAS FM ended up being one of the accused persons before the ICC in relation to his role as a broadcaster. Part of the discussion is in the report is attempts that were made to raise or bring accountability in the build-up to the elections of 2007. So the UNDP, for example, had established a media monitoring arrangement with a private service provider, and the service provider kept fingering CAS FM as of interest to the authorities. And there was a formal attempt to bring accountability against CAS FM, and that process ended with a finding by the Media Council that there had been no wrongdoing on the part of the radio station, but the radio station hadn't done enough to control calling the participation of people who called onto the radio station. So the finding was to the effect that there was no irresponsibility on the part of the announcers or the members of staff of the radio station, but the way they controlled the people who called onto the radio was something of concern, and that there should have been something more should have been done to ensure that whatever the content of the call-in participants was better controlled to deal with insightful or hate speech. The other major preoccupation of the report is to do with leafleting. There are many incidences of leaflets that appeared in different parts of the country, and these are leaflets that announced that were warnings that certain people the presence of certain types of people were undesirable in certain parts of the country, or warnings to the effect that they were going to a build-up of tension that was the result of leaflets. One major incident was is the incident in somewhere in the North Rift Valley, where a car was arrested that was distributing leaflets. And that car was then brought to the Rift Valley Provincial Headquarters in Nakuru, and together the car and its occupants, they were actually pinning leaflets somewhere in North Rift, in a particular part of North Rift, and then they were brought into the provincial headquarters. After some investigation, it was found that the occupants of the car were actually members of the police service. They were working at the office of the president in Nairobi, and they had been sent as part of what was an official order to spread leaflets that were against the opposition ODM. And actually the leaflets in particular were against Raila Odinga, something to the effect that if Raila Odinga was elected president in 2007, he would hang the Kalenjin or something like that. So when they were arrested, when the true identity of the people arrested was discovered, it was a cause of some embarrassment on the part of the government, because these are officials spreading hate speech or spreading pamphlets or leaflets, but they were not in uniform, so they were doing this in sort of some semi-private capacity. So then the report of the commission devotes a chapter to the media and the role that the media played or should have played in the build up to the violence of 2007. The commission called in Bitange Nemo, the permanent secretary for information. They called in the Editors Guild, then headed by Macharia Gaido, and who was then a senior editor at The Nation. And the tools, the reflections of those two are interesting for this discussion. And Demo told the commission that the government did all it could within its powers, and the third person who was called into the discussion by the commission was the Attorney General Amos Wako at that time. For his part, the Bitange Nemo said, given the tools that were at their disposal as the government, they did all they could to control the use of speech for promoting violence. And one of the things they did was something at the behest of the Ministry of Interior, was to suspend, at the height of the violence itself, to suspend the live coverage of speech, because that was a way of controlling or dealing with incitement. And then he said that they received backlash as soon as they suspended the live coverage, because the media houses then went to court and said their freedom of expression was being unfairly curtailed. The Attorney General told the Commission that, for his part, the curtailment of live transmission was definitely illegal and unconstitutional, and is something that should not have been done. And that is why, when the media houses organized themselves to go to court, he immediately advised the government to rescind its directive, and live coverage was resumed. For his part, Macharia Gaido, speaking for the media, said that the media acted with restraint throughout the entire period. There is a lot of footage and a lot of speech that it withheld from the public out of an act of responsibility, and that if it had put out all it received, the situation would have been much worse. Macharia Gaido concluded that if politicians and others light up the country, it is not the responsibility of the media to put out the fires. If politicians go out there, cause violence, then they must put it out themselves, and it can't be media to cover up their shame. So basically, making the point that it is not media that builds or instigates violence. All that media does is media is just a true mirror of what is happening in society, and the ugliness of what was happening in society at that time was the responsibility not of the media, but of politicians, who are then now turning around and blaming the media. These reflections and these discussions within the pages of the report of the Commission actually, I think they reflect the dimensions of the dilemmas as to how to manage dangerous speech or hate speech, or whatever terminology you may use to call it. In the period after the 2007 violence, certain reforms were instituted. One of them was the establishment of a commission, the National Integration Commission, which came together with a statute, and that statute, for the first time, regulated what is referred to as hate speech, which is dealt with, I think, in Section 13 of the Act. And I'm not going to go into the technical definition of hate speech, but it is sufficient to say that for the first time, a direct offense or a direct crime that has to do with violent speech, hate speech, or whatever you may call it, was now part of our statute, but also a focal institution of the government had been established to monitor for and enforce the law against the use of violent or political violent language for political purposes. What have been, or what were the immediate experiences in an attempt, or what have been some of the experiences in the country in our attempts to bring accountability for this kind of dangerous political language or hate speech or violent language? I think I would like to make a number of reflections in answer to that question. One, violent speech, if you go by those first two quotes of 1960 and 1961 that I quoted, the reflection there is that this is an old problem and it isn't necessarily just recent. The second point is that if politicians and others make violent speech, then it falls on fertile ground. If what is cited in those reports is true, that from very early on there was a very high level of ethnic and other subnational consciousness around which populations in the country were already organizing, then it means that if people are using that and promoting that kind of speech and using it for the public, it is because it is proven to work. It is because there's something about the general public that is welcoming of the use of this kind of tactics, and that is why again and again it has been very successful in deployment for political purposes. The third point to make is that this kind of violent speech is not necessarily violent in nature, and this is because of the use of code. In the example of what was happening in 1991 is good enough, and there are very, very many examples across time. In 1991, the people who are undesirable in the Rift Valley, or in one episode of a violent buildup, were referred to as Madoado. Madoado, the meaning of Madoado is what is the formal meaning of Madoado? It doesn't mean. It is a harmless word in and of itself, but the way it's used, it deploys in a way that has a particular and specific meaning, and that meaning is very context specific and communicates very effectively with the intended recipients of the speech. More recently, and if you read the pages of the Waki Commission, there are other permutations of othering people that are used there, and many types of words that have been deployed. So the fact that people are able to use code and communicate effectively at a subnational or in a sectarian or subnational level makes the use of this kind of speech particularly effective as a form of communication, but makes it difficult to bring accountability against it. The other point to make is that violent speech builds on localized grievances and incidents, making it difficult to establish a strong chain of causation. So if you go back to the incidents of 1960-61, the colonial government's report speaks to a desire to control local areas as by the people living in the Rift Valley as the basis of the strife that was then noticeable among them. That is an old issue that has not gone away. If you come to the 1964 incident, the incidents were about boundaries, and the boundaries were ethnic in nature. They had just been established by the Boundaries Commission, and so each group was claiming that this is the wrong boundary and were making the claims through violence. There are meta narratives that are driven that drive the violence, and those meta narratives include narratives about before the colonials came, our land extended from here up to the end of all you can see. Those people living on that land, that was originally ours. So when those meta-narratives are at the bedrock of what people feel and think about the situation they're living in, it's very difficult to sometimes localized incidents that are said to be the reason for the violence are mere triggers rather than the causes of the violence. If you go to the incidents in Owiro Farm, which was a Luo-dominated farm in the Rift Valley that was attacked during the 1992 violence, the incident there was about a brawl that took place in a bar between, I think, people of different ethnicities, and that brawl is what opened up the violence that followed. That a brawl that is ethnic in nature is, I mean, it can be argued that it can't have been the cause of the violence. It must only have been a trigger for the violence, but that the cause of the violence itself lies in this meta-narrative space, and that becomes very difficult to ascertain because meta-narratives are not necessarily stated or discussed openly by the people who hold them, and yet they are drivers of their decisions and their actions. The other point to make is to do with the forms of distribution of speech. In the 60s, when communications were not well developed, mass communications were not well developed, it was probably through word of mouth, through rallies and so on and so forth. With the development of information technologies, the distribution of these forms of speech has become more impersonal. Leafleting, leaflets appear overnight, or rather people wake up in the morning and found leaflets were dropped in the morning. Nobody knows who dropped them and why. It becomes more difficult to establish accountability because of the different and easier ways of making large segments of the population aware of these types of speech. So it doesn't have to be spoken by identifiable individuals for it to have been said. The other point to make is that this kind of speech in the early years, it tended to be marginal in nature. Self-respecting politicians were not going to say certain things in and of themselves. That is still the case even now, that certain things will not be said by self-respecting politicians. They'll pass that on to certain people who will clown the words out of their mouths, but it is clear that those people have been sent and they are speaking on behalf of others. But increasingly also, mainstream politicians, the ones who are thought to be more self-respecting, are themselves in their own words, the ones that they would have clowned away through others, through surrogates, those words are coming out of their own mouth and out of their own media establishment. So to give the example of the vernacular stations were sort of thought to be lesser than the mainstream radio stations, but it is not just the vernacular stations that were spewing hate. It is also the more established media organizations, including the ones that are owned or controlled by the more self-respecting members. I've got just 3 other remarks to make, if you will allow me. The third last point to make is that what has been the experience with regard to attempts to bring accountability for these types of speech. One of the attempts made in 1994 was against the late minister then for local government, William Olentimama, for incitement. This was really actually political speech that he had made throughout that season to the effect of certain people were not desirable in the Rift Valley. When attempts were made to prosecute the minister in the High Court in Nairobi, the establishment staged an Occupy the High Court incident in which a large number of people, about 4,000 of them, entered the courthouse and occupied every place, including the magistrate's seat, and that was the end of the attempt to bring accountability against Imama. More recently, after the onset of the Integration Commission, there was an attempt to bring accountability against a minister from the coast, Makwere. That was also met significant headwinds, technicalities of procedure, and ultimately it petered out and it was never actually referred to. So the record of enforcement is not particularly high or encouraging, and the attempts to enforce is weak. The other incident worth referring to is how the Akiwumi Commission itself was dealt with. When the commission finished the work in 1999, the commission report was shelved, and then towards the end of its term in office, the Kanu administration I think realized that it needed to release the reports to the public on their terms. So in 2001, the Attorney General released the reports to the public after almost 2 years of delay since the commission had finished its work. The Attorney General then wrote to the Police Commissioner, Philemon Abongo, directing him to investigate people who had been mentioned in the report of the Waki Commission. The director, the police commissioner appointed a task force to investigate those people, and the task force went onto the ground into the Rift Valley, and there's an exchange of mail between the Attorney General directing the police and the CID to investigate, and a letter from Philemon Abongo of 2001 summing up the findings of the investigation they had done in an attempt to enforce the recommendations of the Akiwumi report. And one of the findings was to the effect that when they went to the ground to try and investigate, they found that there was no linkage between the things that had been reported in the report, in the Akiwumi report, and the evidence on the ground, and some of that evidence was something that had been picked in the media, and it had become very difficult for an investigation to be carried out. So what the police were erecting as a barrier to accountability was evidentiary in nature, that we couldn't find evidence because investigations of this nature are difficult to carry out. So basically, that for me was a choreographing of closure of the issues that that had been raised by the Akiwumi report in anticipation for the expected retirement of the Kanu administration at the time. I'm coming to the end. So the conclusion is that the regulatory tools are blunt and ineffective, as shown by the examples that I have provided. But moreover, regulation raises unresolvable demands and unresolvable dilemmas about free speech. I've provided, on the one hand, the argument by Macharia Gaido to the effect that it is not for the media to correct the bad manners of politicians. The politicians must themselves be responsible for their own manners. What the media does is just truly reflect what is going on in society. So there is that one side of that you can't stop this because we are not the cause of it. We are merely reflecting what people are saying. In the pages of the Waki report, and this is really the way I also view it, it fails to make a conclusion as to how hate speech should be regulated. The commission clearly says that if there was an out-and-out effort to control media or to tell media that we are on the lookout for whether or not you're going to cover or promote hate speech through your coverage, that is going to have an undesirable effect. But on the other hand, so the commission was basically saying that what is needed is to deal with this issue on a case-by-case basis, and that the freedom of speech is the guarantee of freedom of speech is far greater than any slippages that may result as a result of the overuse or the misuse of that freedom of speech. And that is where I will stop. Thank you very much.
Okay, thanks a lot, George. Very quickly, because I know people are waiting to ask questions or respond. One of the things that you've done is you've taken us through the difficult history, I think, of Kenya, and trying to show that, one, the history is mixed in, or rather stranded in with the freedom of speech, the expressions of political expressions that generate tensions, or which people think should be regulated, coming from Kenya's history. So obviously, hate speech, as you may call it, or ethnic tensions, and its contribution to political tensions actually is an old one. So we're not necessarily dealing with that problem. And that we've been dealing with it for almost 60 years is in itself a manifestation of the fact that perhaps you're not using the right tools, the right approach, or maybe we are trying to regulate something that should we even regulate, or using the right approaches first. You went through, I think, incisively through commissions. The way Kenya deals with these things is through commissions. So the Akiumi Commission, the Waki Commission, and the findings of those commissions, which actually say that, yes, the Kenyans will express things that are not just hurtful to others, but at the same time generate violence, or at least violence. I'm one of the few people who want for us as a society to create the distinction between words which express bad manners and poor culture, and how actually that we attribute violence to that. Because I think even as lawyers, and we've had lawyers speaking to us this morning, understand that in the commission of crime, it is not enough to think about it, but basically in proof of a crime, you have to say that somebody had that malice aforethought, which then they acted upon. If they have only one, I think then that criminalizing free speech because somebody has said something and then somebody else who feels emotionally reacted to it should necessarily make the first actor. But that's what you show here. And then there are regulatory tools. And then in the form of accountability, I think there's very serious struggle. You mentioned specific cases, William Timama, prosecution was attempted here, that this was a prosecution that was intended to fail. So the record of enforcement in Kenya is very, very poor. A report is released by government on its own terms, and it basically was a choreography of closure, as you call it. That's a nice phrase to reply to it. So you conclude with the view that regulatory tools, especially in governing political speech, is blunt and ineffective, and that regulation raises unresolvable dilemmas, as you quoted Macharia Gaito saying, that if people think that others are not, well, at the worst subhuman or have certain attributes that we do not like, it's not upon the media to then shape those messages in a way that does not cause grievance that some people may show on the other. So basically, that to the extent that is possible, the media should just give us back what we say about each other or about other things and stuff like that. And I prefer that at a that most of these things, whenever harm takes place, it should be handled on a case-by-case basis, because regardless of the protections that we've seen in the Constitution, if we started to trim it, I think we'll find that in a very short time there might be no freedom of speech that exists at all. So you conclude by telling us that these things need to be handled on a case-by-case basis, because otherwise we harm the greater good that comes from having a constitutional right. So ladies and gentlemen, here is an opportunity to ask questions. I know we've gone beyond our time, but we'll extend, if the speakers have time, for another 20 minutes or so. So I'll ask you all, anybody who has questions, there's a facility here that allows you to raise your hands. And you raise your hand, I'll allow you the opportunity to ask a question. Please just introduce yourself and ask the question directly. If you have comments to make, please make them quickly. I'll try and limit each of us to 2 minutes or less, so that we have at least a good number of questions asked. Does anyone have questions? I do not see any on the platform so far, but if anyone has, please switch on your microphone and you can ask that question to either Daisy Jackie or to George Kigoro. Any questions? All right, looks like there are no questions. So let me ask them. I had my own questions here and there. And this is purely rhetorical, so I'll fix it mostly to George, Daisy. Of course, Jackie can contribute as well. You see, we are seeing the problem with a fractious society such as our own will obviously have tensions, and that's the reason we have government. So it's upon government to actually try and manage to ensure that the public goods, which is basically keeping people safe, ensuring that stability is maintained, is. And my thinking is that public sector in Kenya uses the failures, its own failures, especially as you showed, that sometimes it's actually government operatives who are themselves driving narratives of division. What exactly is wrong with hate or rudeness? What's wrong with saying that I hate person X and Y? I know Madadwad sounds very crude and all that. Why should government regulate personal opinion about other people? Because I think that if you could see it, it wades into opportunities in which government then uses conveniently public safety as a pretext to control speech that it does not like. So I'm just asking myself here, it sounds rhetorical, but I think it's instructive for us in public literacy around the Constitution. What exactly is wrong with having a low opinion of others? I have a low opinion, for instance, of the Taliban. I mean, many people seem to think that American propaganda has given me, I'm misinformed, I've been brainwashed by the US, and therefore I think that the Taliban, they're very nice and well-perfumed men, but I just don't see it because I have prejudices. But I mean, I despise those guys. They probably despise me as well. But what's wrong with that? I'd just like you to let us know why society cannot function or law cannot function well enough to give us protections, but that we have to put it on the public domain that people should love each other. I'll reverse this. I'll ask Daisy first, and then I'll come to George, and then Jackie can let us know as I wait for the others to ask questions. So Daisy, please let me know why. Why must we all hold hands and sing Kumbaya and hug each other, even if the Taliban and I are streets apart?
Well, Kwame, it's an interesting question. Can you hear me?
Yeah. Yes, Daisy.
You can hear me? Okay, I'm trying to turn on my camera. I don't know if it's... okay, that's an interesting question. I think I will say, for one, good manners. It's not good manners to go around hating on people. Good manners dictates that we must be tolerant, that we should be accommodative of others. And you can imagine if everybody was, or let me say, we've been conditioned to understand that respect and good manners means that you don't say things that would hurt somebody else. This is something that we've learned from even as we grow up. We teach our children how to express themselves in a manner that doesn't offend or hurt other people. Now, you can imagine if we all went around expressing our hatred, expressing our dislike and everything, given the fact that I think by and large, you talk about us being a fractious society, but I would say that Kenyans are emotionally unintelligent, so that we do not know how to express ourselves with dissent or accommodate dissenting views without meting out violence. So imagine if you go around saying, I don't like this one, I hate this person, and everybody gets into that mode, and people decide that they will also express themselves by punching you or slapping you because you said you don't like them, then we end up, degenerating into a whole mess. And we've seen that that doesn't augur well. I think what we need is to come to a point where we're able to channel, even if it is dislike or even hatred, to channel it in a manner that is not hurtful, or I don't know if the right word is hurtful, but is not communicated in such a way as to trigger an unpleasant reaction. Unpleasant, I'm thinking about things like, violence. And we've seen that when we go to places where I think George has given us a whole raft of incidences where people who hold a certain different persuasion end up being subjected to violence. If we can learn how to dissent and express ourselves, whether negatively, even negatively, in a way that people can also take it and respond without violent acts, I think then we'll be that much more. I think that's exactly what debates were about. When we were taught how to debate, you were given a topic and you were told, you be for, you be against. So it wasn't really about whether you are persuaded, you are for or against, but frame a debate around it, And so you weren't throwing shoes or stones or something at the other. You exercised your capacity to think through an issue, to exercise restraint, to think critically around it. And so I think it is something that we can build. We can build into society, ability to be able to take that. I think we've seen it in other societies. I mean, see, in America, you can say how you hate the president and you're not going to be arrested. You can even abuse him to the face. We've seen in other democracies, you can demonstrate, you can pour, paint on your leaders, throw eggs and tomatoes at them. We've seen it being done and they get away with it. I think we all recently saw, what's his name? Emmanuel Macron even being slapped, So, I mean, in other jurisdictions, they seem to have built the capacity to be able to take those knocks without taking them too personally. In Africa, not so. In Africa, even when you just express legitimate dissent based on law and, civil society groups, we've been on the receiving end. The minute you just go to court and the courts fine against the state, we've seen things blow up in your face. The president goes all ballistic when the courts, a legitimate institution of governance and a third arm of government, rules against him. He doesn't want to hear. He goes ballistic and revisits them in a nasty way. So we haven't built, we've yet to build that capacity to be mannerless and be mannerless and keep the peace, as it were. So I think that until we're able to do that, people must exercise good manners and exercise restraint and not go around hating on people. Although, right. Hey, you are allowed to dissent.
All right, thanks a lot, Daisy. Let me ask George. George, what about you? What do you think?
I talked about meta-narratives and the fact that the holders and they are the basic, they unstated basis of our view of society and our decision making. So when people say things they say, when they speak, they are understood differently by the recipients of their messages. They are viewed not as individuals but as representatives of groups, as spokespeople of opposing groups, and so on and so forth. So one of the difficulties then becomes the danger that if I say this as an individual, I can be understood. I may be understood not as speaking. If I hate as an individual, it is very easy for that to be taken.
Sorry, George, somebody had their microphone on. So please go ahead.
Okay, so because without choosing, so it can be assumed that when we say the things we do or we hate the way we do, we can be assumed to be representatives of groups that we are ascribed to, and then that can spiral out of control. So that is why I think in a society such as ours, with so many of these meta-narratives that are not stated and that are not put on the table, it's very easy for people to be misunderstood or to be understood to be speaking on behalf of others. When Keretu Morongi spoke in at the end of Moi's term, Keretu Morongi said, now let Moi go home and look after his goats and watch governance take place. This was Keretu Morongi, an individual speaking to another individual called Moi. There's a superficial understanding of that, which is what I've just said, but there's a narratical way of understanding that, which is this is one side of the country that characterizes as another part of the country as all we can ever be is we are only good enough to be goat herders. We can't run a government. We can't run a country. So those types of things being ascribed to actions of people on behalf of groups are they're present and living dangers among us, and things easily get blown out of proportion.
All right. Jackie, do you have a comment before I can go to a second question?
Maybe I could just add that the requirement in law is not just that hate speech is prohibited, or the use of abusive or insulting words just for the bad manners part of it. I think the emphasis is on the intention to drive ethnic hatred. The law actually emphasizes that what is determined that hate speech is not merely abusive or insulting words. Bad manners, if someone wishes to, can proceed to do that, but when the underlying intention is to stir up ethnic hatred, and which by extension, as again George explained, is likely to cause violence in some instances, that is what is expressly prohibited by law. And I think the same is even in the Constitution. They mention that when they emphasize or when they talk about the advocacy of hatred being an exception, then the underlying reason that they mention there is that the incitement is where the incitement is likely to cause harm. So I think the main issue there is drive ethnic hatred, cause violence, cause harm. That's the primary basis as to why hate speech is disallowed, not just to disallow bad manners, but for the likely consequences that are likely to result from it. Thank you.
All right. Okay. Let me just say this because I'll be asking each of you to conclude in a while. So responding to both Daisy and George and Jackie as well. If you say that Kenyans are emotionally unintelligent, thanks to the fact that we have free speech, others that have been very upset, Daisy, for calling us emotionally unintelligent, and I would just decide that you've abused all of us, right? But I think perhaps, as this instance shows, we should have the right to insult people who are unintelligent. We should. I mean, it's a right I particularly enjoy. We should have that right. And I'd like for us to reinforce the fact that government should not be our private psychiatrist, where if we feel insulted, we go to government to use the instruments of coercive power of the government to cane the people we want caned, or to ask people to love us if they do not. Nothing wrong with that. George, I think you mentioned a very important thing, and that tells us why this is not child's play, that we are here. You see, those meta-narratives themselves, which are sometimes very sensitive, based on facts, but also certain interpretations of facts, which might not be right, are the narratives that themselves give people, in some places in Kenya, a sense of regard that, look, we fought for Kenya's independence and therefore deserve to be treated as the first child of the country. And that if somebody asks such historical questions about to what extent did person X father or person X contribute, it creates quite a lot. But my view is that the very fact that those narratives exist, because we don't want to read people's minds, I think they should be expressed. However crudely so, they should be expressed. If somebody thinks that I owe them anything, and I need to shut up when the big boys are speaking about Kenya's politics. I'd rather they tell me, because I'll tell them back why I don't think they should. So it just tells us how important the questions, these meta-narratives are, so that we actually confront the reality of what a complex society such as ours is. My fear about what you all say, and you're all lawyers, and maybe that reflects, is your view that society gets, or rather that because
Oh dear, the moderator's hand.
Oh, I thought it was me. Oh, there he comes.
No, it's still hanging, according to me.
Yes, it is.
Okay, am I back?
Yes, you are.
The internet is
Okay.
limiting your expression.
Yeah, yes. But the point I was making very clearly is that if we decide that because society has certain attributes which make liberal expressions of freedom possible, then we are actually saying that perhaps the Constitution gave us more rights than we deserve. That's the danger I have. And it's a very, very common view in Kenya's public sector, who we all know did not support the constitutional amendment because it was taking away rights from them. And that is the new argument they were bringing, and which part of what elevated, or rather, it's part of what lit up the BBI process. Not in terms of the intentions, but the underlying part of it was actually people trying to claw back things by telling us that we are not sufficiently. So that danger, I think, does exist. But I'd like us all to close. And part of one of the things that I'd like to close with is, I have a fear of political correctness, because once you get political correctness and political correctness about political correctness, it's a slippery slope towards going back to managing people's expression. And expressions are some of the most, it starts from a very intimate level, but it also goes down to the public sphere and everything, and what can't be expressed. And I'll give the example of the Institute of Economic Affairs. When this institution was formed, to actually say that privatization should take place, it still is, but to actually say that privatization should take place was considered a foreign concept, which suggests that you've been influenced by certain political ideas and you hate Kenya. I mean, they didn't use that word. That's a very woke system. They use it today. But that you hated this country because you hated the people who were running it, and you are suggesting they're incompetent. So these are conversations that we must have. But I'd like all of us to complete, to finish today, to give our final remarks. And I'll start with George, then I'll reverse it to the others. So George, you go first. Any concluding remarks?
Thank you very much. I think, Kwame, you've brought a very interesting point there, that one of the dangers of then regulating for speech or regulating expression is a promotion of political correctness, where everybody, where the issues, the difficulties that we face as society, those meta-narratives that drive us and drive our decisions exist but are not discussed. So it is a good thing when people disagree and people are rude and people say the things that they feel, because then it is easy for people to confront each other's views and to have a society that is vibrant and dynamic and ongoing. Where this has what is lacking is obviously situations where expression has gone overboard and is proximately related to situations of political tension and violence. The accountability for that has not been promising. And it has not been promising because because if the cause of that is one of the dominant political actors, and that actor is in their political establishment, then that is the way they intended to be. So there can be no accountability. So, for example, the point I was making earlier on, that these used to be sort of marginal voices, but now if you have Cambridge Analytica being deployed in an election. That is very much, it's a privatization of, I mean, it is as mainstreaming as can happen, because it's the dominant people saying through a contracted voice very nasty things about their opponents, and it's very difficult to see how accountability can be ensured. But on the other hand, if you've got the opposing side saying similarly nasty things, you can't have accountability against them without taking huge political risks of, for example, bringing down the entire country. So these are extremely difficult questions to discuss, and my parting shot is that there are no clear answers, and we must keep talking more and more about it, and people should say what really they think about everything, and it is easier to deal with that than for things to be swept under the carpet, and for us then to be surprised by violence or by instability down the line that was not foreseeable. Thank you very much.
Thanks a lot, George. Daisy?
Thank you, Kwame, and thank you to the IEA family for bringing this discussion, I think, at a very timely time, a year to our general election, because it is really during the campaigning and electioneering period that people tend to say things, and things tend to happen in terms of the curtailment of freedoms of expression. It's the time when we want to be heard in our various different groups. One thing, excuse me, we must not run away from is the understanding. I mean, the fundamental thing that the point we must begin at is that the freedom of expression is actually inherent. It is an inherent right. It cannot be suppressed. I mean, you think about it, even in little children who may not know law, who do not know constitution, they have not been exposed to too much. But anytime, even when children feel that things are not going right, you will hear them saying, it is not fair. They will cry out, it's not fair, or you are not being fair. And so it's inherent in all of us that we want to be able to freely express ourselves and not have that freedom curtailed. We also do know that there are situations where that freedom is abused, and it's abused terribly. And I will speak about the Kenyan situation. I think more often than not, the freedom of expression has been abused by political actors and has been used to incite violence, to curtail a legitimate expression of ideas and the marketplace.
Looks like we lost Daisy.
Across. Am I here? Can you hear me?
Yes, we can. You're
Hello?
back.
Oh, sorry. Even the internet is trying to curtail me. So I'm saying that at a time like this, it is important. This is an important discussion, and I hope that you will build on it. But we do know that for a functioning democracy, freedom of expression is critical. And because it allows us to have a marketplace of ideas. So this the importance of this conversation cannot be gainsaid. Moving forward, we also know that the threats are there, and we must keep a lookout for those threats, because where power is threatened, where advances are being made, maybe one group is becoming stronger in terms of being able to express themselves more coherently, and people are more persuaded, then the government will definitely look to curtail. And I think that these are things that we must look out for. For women, this is an area that we are definitely going to look into, because we know that freedom of expression has been seriously limited for women for a long time, even by media, in terms of being able to profile women leadership out there. But moving forward as Kenyans, I think that while we may celebrate this right to freely express ourselves, we must be careful not to abuse it, in the sense that not to incite violence or to incite people against others. We must learn how to hone our skills towards being able to coherently and what is the right word? I was going to say, you know, without offense, although sometimes I think you cannot avoid offending. I know that I offend very many people, and I simply feel that I speak the truth, but in so doing, I tend to offend very many people. So I think we need to build up our capacity to receive truth and be on the lookout. I think we need to be ready to fight for this freedom. I suspect that we are going to see serious limitations on this freedom in the not too distant future. We've already seen it. COVID has been used as an excuse to curtail that freedom. And I don't think they are going to stop at that. I think they are going to take this thing as far as they can, which means that we must be ready. We must be ready. We must be ready to work together to ensure that this freedom is not curtailed. And I say this looking at you, George, and looking at you, Kwame, that we need strong allies in this fight. Because I really do believe that in the not too distant future, we will have this conversation differently, where we will be talking about how do we curtail the ability of government to curtail our freedom of expression. And we must be ready to fight that fight, because if we do not, especially with the whole debate as it's coming, we look forward to what's going to happen with the BBI. Of course, you know that yesterday with the Linda Katiba, our tweet chat was shut down. We don't know from which quarters, but it was actually shut down. That is a curtailment, and it was really gaining traction. So we need to start looking out for this and putting our heads together. So Kwame, I hope that this is just the first of the conversations that IEA is convening. Convene us again. Let's convene one another. Let's have this discussion, and let's have strategies on how we protect this right, but also how to assess the limitations that may be put upon us in terms of their reasonableness. You know, if they are reasonable, and if not, then we fight on. Thank you so much, and I wish you all a good afternoon.
All right, Jackie.
Okay, thanks. So in concluding, I'd just like to emphasize that as established by law, in construing this right to the freedom of expression, we must look at the interpretations that give an individual the maximum capacity to enjoy the right. So I think the judiciary, for instance, has a big role to play going forward in terms of helping us in more progressive interpretation of the law. We've seen that in the past that the most responsive ally that the public seems to have nowadays in terms of the three arms of government, the main one that we can rely on is seemingly and increasingly the judiciary. So I hope that for enjoyment of this right, the judiciary can play a more pronounced role in providing a better or more progressive interpretation. I know some of the previous case law has actually addressed that and mentioned that in giving meaning and purpose to any law or section of a law that is contested, that we must seek to find, to give its meaning, the meaning that gives the individual the maximum right. So I think that the judiciary has a key role to play there. And lastly, I'd also like to just say that we cannot understate the importance of the freedom. Yes, there are limitations which are recognized even by international statutes, but at the same time, let's recognize that it's interconnected to many other rights, and for us to be able to enjoy and articulate and demand for those other rights, that the freedom of expression must be upheld. So thank you, and I'd also like to thank my co-panelists. Thanks for agreeing to be on this discussion with us.
All right, thanks a lot. I'd like to thank all of you, but I'll just say 2 points. One of the reasons why whether it's courts or regulators of free speech should be urged to err on the side of letting free speech go ahead is because one antidote to free speech that is a lie or that is disconcerting or that is uncomfortable is that another form of free speech can actually be used to level it without necessarily resorting to state power. So that's the first. The second lesson that I've learned here is we live in a complex and very complicated world, and therefore it's upon us to actually see that on a case-by-case basis, the application of those regulations and safeguards actually tends to bring us back to good ground. But I'd rather, again, reinforcing Jackie's point, is that I'd rather the courts made those than political operatives or just state officers who are not interpreting law. So I'd be more comfortable with how courts do that. My third point is, and Daisy mentioned this around cancel culture. And I think because cancel culture is a form of expression and association, if people want to cancel somebody like me, they probably should be allowed to do that. But I think the one thing that we'd like to distinguish, and George mentioned this as well with both Joyce and Daisy about Oxford Analytica, was that one of the ways in which we have to be careful is where government starts to use private arms or private people with the incentive of using public money, which is taxes, to then curtail free speech. So that means we need to have a distinction between what we can regulate in terms of limiting free speech or expression by state officers. I think there are some things that state officers should be forbidden from doing, but which a private person, partly because you're not using state resources or you're not necessarily supposed to be using the imprimatur of government direction to say them. But as all of you seem to confirm, it's an interesting area and one in which we need to watch, because I think the right to free speech among the rights you have regardless of your other station in life, and the ability to communicate with government and others has immense value, both as a right in itself, but in instrumentalized forms, whether it's for communication, whether it's for income, whether it's for expression of artistically, intellectual thought, and all those others. I thank you all, Daisy and George and Jackie, in all your private, but also in the work that you do in protecting the Constitution. I have increasingly become clear that if there are things we must hold sacred in terms of secular sense, I think there's the Constitution of Kenya is one for which, whose sacred nature in that way, I do not question. And we have to then understand that what it allows us is that then what that means that everybody else and everything else should not be above criticism. So using those constitutional protections is important. It's part of the reason we've convened here, both in people we associate with as members of the IEA, but also our partners in George and Daisy. So for all of those who've been here, thank you very much. I sent out a link to an interesting article on free speech and its modern manifestations in terms of cancel culture and all those, which you all will have access to it in the chat box. But I'd like to thank George, Daisy, and Jackie for spending your time today. And I think we've had a fantastic and very illuminating discussion. The Institute of Economic Affairs is an association. We have a membership. We're on a membership drive. If you'd like to be a member, please send an inquiry on our email, admin, @ieakenya.or.ke, and we'll get somebody to come back with you, and to guide you about what the joining process is. But once again, thanks a lot, George. Thanks a lot, Daisy, and thanks, Jackie, as well. On behalf of the Constitution Law and the Economy Program of the Institute of Economic Affairs, I thank you on behalf of the IE and hope we all have a good afternoon. Thank you very much, and look forward to the next discussion. Bye, everyone.
Bye-bye.
Bye.
Bye.